Thank you very much, member. Recognizing the House Leader of our third party.
Thank you, Mr. Chair. I will be the designated speaker for the third party. And I'll just begin my statement and reflections on second reading notes. First, I want to note that the third party will not support Bill 9 in its current form, and later in my presentation I'll outline the fundamental flaws that need to be addressed. This is not just any legislation. Freedom of information is the foundation of open, transparent, and accountable democratic government, period. Bill 9 represents the culmination of a 34-year effort of the NDP and other governing parties to convert freedom of information to freedom from information. And in the balance of my remarks today, I'll outline why that is so. Not only that, this Bill 9 represents another step of this NDP government's efforts, supported by every member of Caucus, whether voluntary or whipped, away from open, transparent, and accountable government. We look for a government that builds consensus rather than division, and the lack of an effective Freedom of Information and Protection of Privacy Act prevents that from happening. We now know the concentration of power and decision-making in the Premier's office, the removal of checks and balances, such as the Merit Commissioner, the lack of oversight and involvement of key legislative committees, the move to put everything in opaque, cabinet Premier-decided regulations where there is not the scrutiny of the legislature, the use of budget cuts to justify reducing review or consultation. This is all part of an effort to convert 22 votes, a 22-vote win, into unchecked power. And we know from history and what has happened south of the border that this will not end well. And now, this is being capped off by a disturbing pattern that has emerged where we end up on key pieces of legislation in a tie vote where the Speaker is repeatedly put in the impossible position of breaking the tie for a variety of reasons. And then we have Bill 9. And Bill 9 really is the culmination, as I mentioned earlier, of a 34-year trend to eliminate freedom of information in this province. In the next period of time, I'm going to take you back in time to an era when the NDP upheld instead of bypassed and degraded democracy. I'm going to talk about a time when the NDP built consensus, not division. Then I'll take you through to around 2010 for a check-in to document the reductions in freedom of information that occurred in that period of time. I'll touch down in the early 2020s when fees became a barrier to access. And then I'll turn to Bill 9 and offer some observations on Bill 9. And why is this context important? Because it explains the steady degradation of our democracy in BC to the point where the Independent Information and Privacy Commissioner says he supports a bill that destroys the right to know, as I will show. And no other commissioner in Canada would ever countenance some of the amendments that are proposed in this legislation. Be so for real right now. So let's go back to 1991. It was 1991. The Premier, NDP, Mike Harcourt had just been elected. The Attorney General was Colin Gableman. There was a passionate advocate for freedom of information, an NDP MLA, Barry Jones. And there was a special advisor, one Murray Rankin, who at the time was a big advocate for freedom of information. And there was a young public servant in his mid-30s. I may add, he was quite accomplished. His name was Rob Botterell. And so what happened? Well, in the fall of 1991, the NDP had just been elected, at least in part, on the basis of a promise to bring the most open freedom of information legislation in Canada to British Columbia. There was a great deal of fear about freedom of information and protection of privacy. Public servants that I worked with feared they would have to operate in a fishbowl. Treasury Board feared that freedom of information would be prohibitively expensive. Cabinet members feared that the NDP government would lose control of its political agenda. One cabinet minister at the time I remember raising these concerns was a fellow by the name of Mo Sahoda. And non-government organizations like the Freedom of Information and Protection of Privacy Association and the media feared the legislation would have too many loopholes and would be ignored. Fears that are now fully realized if Bill 9 passes. To address these fears, former Attorney General Colin Gableman and MLA Barry Jones, a longtime advocate, as I mentioned, opted for a very open, inclusive, and transparent legislative process, both before and after the legislation was introduced. I led, as part of my team and working for the Attorney General, extensive consultations inside and outside government. All submissions were made publicly available. Lawyer Murray Rankin provided advice on the Act. I even participated, along with other ministers and senior officials, in a televised debate on freedom of information with a coalition of media organizations on the other side of that debate. We looked to precedents in other jurisdictions, such as Ontario, to find workable, predictable provisions that would stand the test of time. Full openness and transparency of process of how we developed the legislation was critical to achieving a broad-based consensus on what the legislation would do and how much openness there would be and how much privacy protection there would be. It's a rare event in BC politics, and it's hard to believe that it occurred 34 years ago. But in 1992, the NDP government of the day and the opposition, Liberals and others, set aside their political differences and unanimously passed what was then the most open freedom of information legislation in Canada. And I should describe a bit about that process, because the difference in that process compared to the process we go through in this legislature, in these sessions that I've had the privilege to be an MLA sitting in the House, was quite different. We introduced the legislation, and then we went out and we consulted after people could see the legislation. And we didn't have everybody sign NDAs or a select few see it in advance in the way we do it now, or the government does it now. We let everybody see the legislation, and then we sought public input. Then we prepared a report on that public input, which everybody could see. And then you wouldn't believe what we did. It seems unimaginable given how this particular government operates. The NDP government of the day listened to the input, both from those that are concerned about the degree of openness and those that are looking for more openness, and we introduced over 50 amendments to the legislation. And that legislation passed unanimously because we had taken the time to build the consensus across party lines. On that day, there was a promise made by the NDP government and everybody who supported that bill. And that promise to the citizens of BC was that we would have the most open and accountable jurisdiction in Canada. This meant that access to information would be timely, because access delayed is access denied, something I'll speak more about. Fees would not be a barrier to access. We were determined not to charge fees to the public for access to their own personal and general information, the information that they paid to have created. We committed and promised that exemptions to access would be narrow and specific. And when I say we, I mean the government, all of those that voted in favor of the legislation, but all of us that worked on it too, because we were given a mandate that it had to have these attributes. The amount of information you received would no longer depend on who you are and why you want the information. And Bill 9 will change all that. And there would be an independent commissioner free from judicial and political pressure or interference, who would be unstinting to ensure this happened. In short, there would be a new culture of openness within government, and the government at the time said, we need to commit the resources to information management, to systems that are needed to create and have this culture of openness. And I would defy anybody in the legislature to challenge that view. And if they wish to, they should go and have a chat with former Attorney General Colin Gableman and others at that time. This promise was made not only to the citizens of this province, but also to those who rely on freedom of information to hold government accountable. The media, opposition parties, non-governmental organizations, public-minded citizens. And it worked. As I mentioned, in June 1992, after making 50 amendments, the BC legislature passed the Act unanimously. And David Lucadellis, president of the Freedom of Information and Privacy Association, Protection of Privacy Association, and a future Information and Privacy Commissioner, said at the time, with the new amendments, FIPA, that was the name of his organization, nonprofit, can state unequivocally that this is the most open, balanced, and effective information rights legislation in Canada. Later that year, after the NDP's first session, so mid-1992, had longer sessions there back then because we actually spent more time debating legislation and we didn't use tactics to speed it up or move everything into regulation, so there was less to debate except to vote no and have the speaker overrule on a tie. Back in the old days, we actually took a lot of time. So it was later that year, and the Vancouver Sun's Vaughn Palmer, who was also a lot younger then, wrote, "Its most outstanding achievement, which sharply increased its point average, was the passage of a Freedom of Information bill that was handled in exemplary fashion with full opportunity for public input, resulting in what experts agree is the best legislation of its kind in Canada." That was what Vaughn Palmer said about this Freedom of Information legislation in 1992. He's not saying that now, but he was saying that then. And I think it's pretty rare that we hear Vaughn Palmer complimenting this government on the legislation it passes. But most importantly, the degree of openness in the Act was no accident. It reflected a hard-won balance that everyone believed would be respected. How wrong we were. And so now what I want to do is start in on talking about the various ways in which this legislation was dismantled. So let's fast forward to 2010, because I only have 2 hours. And we could go through every year and every single amendment, but I'm going to check in at 2010. And one of the items that we provided in this legislation was that we would have a review every 6 years. And so in 2010, we had that review. And that was a good way, a good timing for talking about the start of what had been dismantled by 2010. And, you know, if it's any consolation, some of this was the result of NDP government amendments, others the result of Liberal amendments. But, you know, I'll share the blame a bit. I won't take responsibility because I was actually advocating to hold on to the legislation and improve its openness. So what was the first one that I want to touch on in 2010? Access to information was not timely. Guess what? Access delayed is access denied. If you have concerns about a decision related to autism funding, if you have a concern related to the establishment of a fund, a Look West fund, if you have concerns about, not about legislation maybe, but about other things that are happening, you would like to see, for example, what exactly was the briefing material that was in front of the Premier when the Premier suddenly decided that this was the time to announce a permanent spring forward in time zones? Or what is the background and what are some of the key issues related to FIFA and what's going to happen later this year? I mean, there's any number of issues, and in order to hold government to account, the purpose of freedom of information is that we can access that information in a timely way. And it's hard to actually use information to hold government accountable 6, 12, 18 months after the fact. It's a great approach if you're a history professor or if you're writing the memoirs of a bad public policy decision or a good public policy decision. Maybe the FOI information will show that the government's fully justified in the approach it took. Well, in 2010, work started on dismantling Section 6. Section 6 we'll come back to later this afternoon. Section 6 of the Act places a positive duty on public servants to assist applicants and respond without delay, openly, accurately, and completely. This was intended to make it clear that the time limits under the Act, such as the requirement to respond in no later than 30 days after the arrest received, would be the outer limit, that the government would move to make information routinely available, that it was modify information systems, filing systems, bring it into, at that time, the 20th century, early 21st century, and actually create a way for information to be released in a timely way. And we did that intentionally. We said without delay. And I'll come back to the latest effort here, which is to insert the reasonable test, because then that opens up the possibility for government, ministries, agencies to say, well, I don't know, it seems reasonable, 60 days would seem reasonable here, and I can probably find some mystical, objective person somewhere that I can create to say, oh yeah, 60 days. We even equipped the commissioner with order-making power to enforce this duty. What was the government's response? Oh, amend the Act. Sound familiar? To relax the deadlines and legalize delay through the stroke of a legislative pen. The 30 calendar day outside response time morphed into a 30 working day outside response deadline. 4 weeks became 6 weeks. But, of course, the government and many of you will not realize that it's changed at all, because this may be, at least for some MLAs, the first time they ever heard that the deadline, in line with everybody else in Canada, was 30 calendar days. But with stroke of a pen, let's make it 6 weeks. That's just the first of a number. The other change that happened and that started to emerge was massive delays in response times. And fees. Oh, we can use processing fees to delay responding, delay the issue, delay getting information so we can hold government to account. Everybody, some of my colleagues on both sides of the House will be old enough to have remembered the harmonized sales tax, that glorious invention that caused a fair amount of foofara until it was eventually eliminated. And so, you know, media outlets, they thought, oh, it'd be interesting to have some information on the harmonized sales tax. And the government said, sure, yeah, no problem. Just write us a check for $800 and we'll start processing your request. And then, of course, the media organizations would appeal. And then the appeal would take a whole bunch of time to deal with. so that 5 months later, there's no information provided. And so that's a history lesson there of how the legislation was used and the fees under it were used to delay access. And, you know, the fact is that it's inconceivable that it would cost $800 to locate and process public records on a high-profile issue like the HST. That information should be at the government's fingertips. And at that time, we didn't have nearly the computing capacity and internet capacity that we do now. But even then, we lived in the era of Google and iPads, and you know, it wasn't just filing cabinets and typewriters. So this information that was requested must have been generated and stored on computers, and instead of building the infrastructure to access it, it was used as a shield to eliminate the access and charge a fee. So, you know, at the time, government records management was either in a shambles, or the government had something to hide and was doing everything it can to delay responding. Either way, the public paid their taxes to have the HST information prepared and have a right, not a privilege, to know what it says, subject to the exemptions in the Act. So whether it's, you know, I've mentioned a couple, but there's numerous issues that we're debating in the course of estimates and legislation in this House. And in between sessions, there's going to be lots of announcements of issues where it would be extraordinarily helpful to hold the government to account by having access to information about that decision. Then the next step in dismantling the Act was a couple of 2 or 3 key decisions of the Information and Privacy Commissioner to broaden the exemptions so that you could deny disclosure of amazing categories of information. And there's 3 areas where this unfolded. The first area was in policy advice. And policy advice can be divided into several categories. Most of us over the years have seen briefing notes. You have the topic, you have background, you have discussion, you have options. And so in some decisions that'll go down in history as the steps towards everything becoming advice, the factual background in a briefing note was treated as advice. The options were treated as advice under the idea that, well, a gifted public servant picked out some options. So he's giving or she's giving, they're giving advice on the options. Well, that's balderdash. That is not what was intended. And it was made very clear in the development of the legislation to everybody involved that that was not the intention. And the documents that related to the legislation was introduced said, for the purposes of the Act, advice or recommendations refers to the submission of a suggested course of action which will ultimately be accepted or rejected by its recipient during a deliberative process. Advice must contain more than mere information. That was the interpretation of the section that was provided to all public servants across government, and that is the basis on which government operated until the commissioner broadened it in a manner that is inconsistent with the same language in Ontario. Now, I'm not trying to relitigate this, but I will for those who remember fondly a fellow by the name of Phil Halkett. You will be surprised that Phil was a little surprised when this change happened. And he came to me because we knew each other and we worked on a variety of issues together. And he said, "Rob, you told me that the Act would require the disclosure of options and factual material. Now the commissioner has changed that." And I said, "Yeah, well, you know, that's the commissioner's prerogative, and it's your prerogative as the government to straighten that out, to amend the Act and take it back to the clear intent that was presented to everybody and agreed on everybody, and the hard-won balance that was achieved when the Act was passed." Well, of course, that didn't suit the government. The government was quite happy to see the legislation evolve in that manner. So my view at the time, based on review of precedent across Canada, is the work that a legislative team does, was and still is, that large portions of briefing notes can be released, including the topic, the background, the discussion, options, and transmittal information. Those should all be accessible for the purposes of Section 13. That was the intention. That doesn't mean that it'll all go out, because there's other important exemptions. There's business exemptions, there's solicitor-client privilege exemptions, there's numerous other, but if it's just the advice part, that should mainly go out. And my view was then, and is now, and opinion, is that it is possible to structure briefing notes so that you separate out the advice from the factual background in a manner that respects the policy advice process, respects the ability of public servants to be candid in their advice, but also equips the public and others, you know, journalists, opposition, others. Businesses are interested in this too, because they have to assess decisions and be able to provide their views on it. And so that can be accomplished. And as a matter of fact, in a future iteration of freedom of information, I was retained by a First Nations client who was drafting treaty legislation, and gazooks, oh my God, what did they do? They created legislation that made sure that there would be routine release of that information, and I can tell you today, I still know those First Nations. They still invite me back. The world has not ended, and their community has access to information that we don't as non-Indigenous British Columbians, the BC government information. Then, of course, just to continue this trip down memory lane, after following the Ontario precedents in this area, having them rejected, having a government that would not go back to the original intent because it suited them to have broader exemptions, we had Section 25, the public interest override, which says that if something is clearly in the public interest, a matter of significant public interest, then it's an override. And once again, for those who are interested in history, around that time, the government made a major decision with major implications for the public. What was that decision? Oh, we're going to privatize BC Rail. No, we're not going to sell it. We're just going to grant a 999-year lease. So we're not selling it. And at the time, that would have been a candidate for Section 25. But instead, it was interpreted as it has to be something imminent of public emergency nature. Once again, that wasn't the intention. Once again, the government made no attempt to fix that. And so, very interesting time we're in, because we're on the other end of that discussion now. So we have the NDP government. This government has said it's going to bring in amendments to DRIPA. And we're going to see those amendments at some point and debate them in this session. And so in that case, the concerns about the rulings and so on have caused the government to say, well, we better amend the legislation so that we don't have the rulings apply. And in this case, we have the opposite end where the rulings aren't quite what we want, and so we're going to we won't make the amendments to deal with them. You know, when going down this memory lane, I do want to quote what is at the heart of freedom of information. Often we're asked, what is freedom of information for? Why do we need freedom of information? And so this quote from John Plamenutz puts it very clearly. If there is to be responsible government, information should be so distributed amongst professionals and ordinary citizens so that competitors for power, influence, and popular support are exposed to relevant and searching criticism. If you don't have the information, you can't hold government accountable. I'll make one last observation, which is that in the course of by 2010, there had also been a demonstrated loss of judicial deference. And what do I mean by that? When this legislation was drafted, we, I'm going to say naively in retrospect, didn't introduce a privative clause because we mistakenly, after looking at other jurisdictions, thought that the courts would defer to the Information and Privacy Commissioner, much in the same way that the courts look at labor tribunals and other tribunals and say, you have specialized expertise, so we will defer to your decision. And that was not the case with freedom of information. And so we have never seen any move to protect the Information and Privacy Commissioner to some extent or to a greater extent from judicial interference. And so that's something that would have reduced this move in terms of the broadening of exemptions. So here we are. We're in 2010 now, and we've identified some of the main changes that occurred in that first period of time since the legislation was passed. But it's still, the promise hadn't changed. The promise was that embarrassment would not be an exemption under the Act. If the information is embarrassing, it still goes out. The promise that administrative convenience is not a legitimate reason to abandon a fundamental democratic right, the public's right to access to information. That hasn't changed. That's the original promise. It's being broken, but that is the original promise. And that the issue about how to balance privacy and access and secrecy or non-disclosure or confidentiality versus releasing information to the public, that calculus, that balance was struck and resolved in 1992. And what we've seen up to 2010, and now it's carrying on, is step by step a move away from that balance. And so, as in 1992, as in 2010, as now, those that passed this legislation promised the people of British Columbia the most open government in Canada. And I'm here today, and I will outline in additional ways what needs to happen to keep that promise. I'm going to now turn to shortly to Bill 9, but I would be remiss if I didn't reflect on the fact that in 2021, this NDP government introduced fees, application fees for the first time. Application fees to apply to get the information that taxpayers paid to create, that you and I paid for, and that we discussed at length in 1991 and before it was passed in 92, and said fees, we're not going to put fees on information and create either a perception or an actual barrier. And so it's mystifying what the purpose of establishing application fees was, and I was sorely disappointed to see the NDP government, and in particular at the time, a former strong advocate for freedom of information, Murray Rankin, involved in that. So in 24-25, how much did those fees generate? $22,590. So it can't have been a revenue generation plan. I have no idea to this day how that came about. It's just one of those items in life where you're gobsmacked and you just go, well, who knows? But it was a step away from the original promise. So now I'm going to turn to, with that background, Bill 9. And I'm thrilled to have members on the opposite side here to listen to my scintillating presentation on Bill 9. I know you've been waiting now for the better part of 45 minutes to find out what will Rob, MLA for Saanich North and the Islands, say about Bill 9. Well, let's start with who was consulted. Let's start with who was consulted aside from the Information and Privacy Commissioner. Well, First Nations were consulted, as they should be. Public sector organizations were consulted as they should be. There were internal discussions, as there should be. There was a look at the 2022 review of FOI. The report was read. There was no recommendation for these sorts of changes in the 2022 report. Was were those that might potentially be concerned about Bill 9 consulted? Was the BC Civil Liberties Association consulted? Was FIPA consulted, the Freedom of Information Privacy Association, who I may add has been a diligent and long-time advocate for this legislation since it was created? Were users of the legislation consulted? Those that have lived experience? Nope. Media organizations? Nope. So the only folks that were consulted about Bill 9 were those in the administrative convenience world. They're the ones that find it inconvenient to respond to requests, find it a burden, and they were sure consulted. And so that's where we start, and what do we find? Well, let me take you through what we find. But first, let me talk about a fundamental point when you're drafting legislation. And in the course of my career, I've drafted hundreds of pages of legislation. I've drafted election acts. I've drafted financial administration acts. I've drafted, obviously, Freedom of Information Act. I've drafted Governance Act, Forestry Act. I've drafted a lot of legislation. And the first thing you ask when you're drafting legislation is, what's the problem? What is the problem we are trying to solve? And then you start to look at policy, and then of course you look at legislation, and you say, okay, well, you know, what's the problem? The drafting instructions are always focused on, we have an issue, how are we going to deal with it? Well, the interesting part about this is that the issue in front of us is not addressed, does not need to be addressed. Let me explain why. In 2024-25, there were 4,691 FOI requests for general information. Those are the requests that those that want to hold government to account or celebrate their achievements and get the information to do so, those are the requests. And what was the average number of days to process those requests? And this is all extracted from the report, the annual report of the Information and Privacy Commissioner. 43 days. 43 days. So what changes do we have to make when we're at 43 days and the legislated target is 30? I mean, that's not bad. And maybe we should work on our systems and the way that information is organized rather than giving the government, the public bodies, the ability to delay responses, to broaden categories of exemptions, to effectively avoid having to deal with it. 43 is not bad. The goal should be to change the policies and systems around FOI requests to get more routine disclosure so you can get down to the magic 30 days. Where is the problem that we're trying to address in this legislation? It's with MCFD personal requests. There were 2,372 requests in 24-25 to MCFD. What was the average days? And the average is only one indicator. What was the average days? 121 days. That's completely unacceptable. That's not even near meeting the need. Why? Because the files that when people, individuals request their own personal information. Those files are huge. So we have provisions in this act to address that. We have provisions around connected services. We have provisions around enabling proactive access to personal information by the person it's about. We even have provisions so that information and privacy commissioners can share information across jurisdictions, which is a good thing. Those are all good provisions in this legislation, and the government deserves credit for bringing those amendments forward, because those amendments are aimed at addressing the problem, which is personal information requests in MCFD. But as is the wont of government throughout the ages, and particularly the one I particularly remember with some, I won't say fondness, with some, this is a new word, gobsmackedness, is Stephen Harper and his ability, when he was Prime Minister, have a government that would create these huge bills and then slip in something that was completely unacceptable with the good stuff, and then just see if we can sneak it through. So, what are the problems with this legislation? The problems with this legislation is that it has the good parts, but it also has the bad parts. What are those sections? What are the sections that turn this from an acceptable piece of legislation into a piece of legislation that either needs to be fully withdrawn or those sections need to be pulled? What are those sections? Sections 1, 2, 3, 4, 5, 6, 7, 13, 15, 25, 26, 27, and 28. And there's still a lot of meat left in the legislation after those are pulled that will enable this government to deal with the overwhelming burden of personal requests at MCFD, not by refusing to disclose personal information to the individual it's about, but by building the systems and the cross-ministry support and the summarization so that those individuals can get access to an initial tranche of information that is really important really quickly, and then they can be much more targeted about follow-up requests. That is good public policy, and this legislation deals with that, but it has this little Trojan horse in it of amendments that are not needed and that put at risk freedom of information to the point where I've been saying it's freedom from information. So let me describe in some painful detail what those amendments are. First of all, in Section 3, some records are excluded where records are required by law to be produced as part of a proceeding. So far, so good. But then 5.1 adds an additional gratuitous, well, while we're at it type of amendment, which is that it excludes record that is not specifically listed or identified, but that falls within a general class of records. So I get the first part of the amendment, but that second part is just, broadening it unnecessarily and completely in contradiction with the fundamental purpose of this act. It gets better. So in Section 5, there is a provision to ensure that the applicant provides enough detail to enable an experienced employee of the public body with a reasonable effort to identify the record sought. And then, new magic words, in the opinion of the head of the public body. So the head of the public body is now the judge. And then the additional test, in a reasonable amount of time. Well, we're in a budget where there's a forecast to eliminate 15,000 positions in the public service. We have huge increasing demands across government given the current economy and the challenges we face. And so you're putting the head of the public body, and by implication everybody in the ministry or the agency, in an impossible position. We have less resources, we have increasing demand on the services we're providing, and we're expected to do this, but we're not going to be able to do it, identify it in a reasonable amount of time. So we better change the act to allow us to extend the start time for the response. So this is all about, you need enough detail in the application. So you can delay starting the response by saying that it would take too long to find the record, so you better provide us with more detail. Boom! We got an extra 30 days added on. But we're already at 43 days. So why aren't we trying to get down to 30 days rather than creating an opportunity for the head of the public body to say, oh, sorry, we love openness, we love accountability, we love transparency, but we can't afford the time right now. That does not reflect what government promised at the time this bill was unanimously passed. And so my call on government is take that amendment out, and I've given you the list. Then the next one, it gets better. The next one is respond without delay, and we talked about this earlier. What does respond without delay mean? It means respond within the 30 days. If you're going to go over, you better have an explanation. You better be working hard to get down to 30 days. And we're at 43. So without unreasonable delay gives you a get out of jail free card. It enables you to say, oh, well, it's not reasonable to do 30 days, so I guess we're good. And, you know, I know from working within government and as a practicing lawyer for 25 years, you can always find an argument to support unreasonable. And it is a ticket to not meet the 30-day requirement or even try. Oh, I like this one. Section 10 amendment. So if an applicant consents in the prescribed manner, there's that word. You know, what I should do is I should be doing a word search of all the acts passed in 1992 and all the acts we're going to pass, say, this spring session, and go through all sorts of fancy statistical analysis and then count up how many times major parts of bills say prescribed. And I will guarantee that prescribed is the favorite word of this government in legislation, both in the last year and this. So may extend the time for responding to the applicant's request by the period to which the applicant has consented. And so what does this do? This creates the possibility that the head of the public body says, well, you know, we're thinking about, it's really tough times, we've got a lot of impacts, you know, we could reasonably delay this for months, your detail isn't detailed enough. Tell you what, why don't we just both agree that we'll respond in 3 months instead of 30 days? and you create an asymmetrical relationship between the applicant and the public body, because you're equipping a discussion where, well, we could take a year and you know you won't get it, but if you give us an extra 40 days, well then, why don't we just both agree? And then, you know, the commissioner won't be involved and nobody will be unhappy because you've agreed. So this creates the possibility to contract out of the fundamental timelines in this legislation and to enable the public body to apply pressure to the applicant to agree. And that is fundamentally wrong. It gets better. It gets better. 16.1. So we have a controversial court decision, or we have a ruling, and I'm not talking about any of the court decisions over the last year. It could be 2 years ago, and I'll explain why in a second. And you say, well, we'd like to get some advice on a, what would it be? Respecting a proposed or existing policy program or enactment. And so what this does is this excludes a whole class of records from this act. And the fact is that when a record is included in the act for the purpose of this act, you still have a myriad of carefully crafted exemptions to make sure that anything harmful to law enforcement, harmful to intergovernment relations or negotiations, harmful to financial or economic interests, harmful to the conservation of heritage sites, harmful to interests of an Indigenous people, harmful to individual or public safety, information that will be published or released within 60 days, harmful to business interests of a third party, harmful to personal privacy, etc. Policy advice, legal advice, cabinet. Oh my God, we have dozens of exemptions, but this government wants to put an amendment in that effectively says, oh, we're not going to go through the analysis of whether there's harm. We're just going to exclude this because the public don't have any right to even maybe know about this. That is fundamentally not what this legislation was intended to do. The legislation, let me talk about the purpose of the act. The purpose of this act, which is the purpose of most acts across Canada, the purpose of the act are to make public bodies more accountable to the public, that's us, and to protect personal privacy by giving the public a right of access to records, specifying limited exceptions to the right of access. And so what are we doing? We're converting limited harm-based exceptions into class-based exceptions. That's exactly the opposite of what the drafters of this legislation and the unanimous legislature intended. It just gets better. It gets better. I can't tell you how happy I am to be able to make this speech with such easy targets. I can tell you that there are much more subtle ways to ignore the principle of freedom of information than this act. I mean, I frankly couldn't believe my eyes. I thought, how did this ever happen? So then, of course, we get to the best one of all, Section 43. Now, just for, just for the record, and because we're over an hour now and we have another hour to go, I'll just read you Section 43, because this really is at the heart of the Act. If the head of a public body asks, the Commissioner may authorize the public body to disregard a request, including because the request is frivolous or vexatious. The request is for a record that has been disclosed to the applicant or that is accessible by the applicant from another source. All good. And we spent a lot of time on this because we saw this at the time we drafted the legislation on direction from Cabinet, of course, on direction from a Cabinet Caucus committee set up specially, where we spent hours going over each clause because we wanted to get it right and it wasn't going to be done off the sides of people's desks. So frivolous or vexatious, standard language, a record that's already been disclosed, makes sense. Why would you have to disclose something that's already out there or that the applicant can get from another source? Then we get to C, 43C, responding to the request would unreasonably interfere with the operations of the public body because the request is excessively broad or is repetitious or systematic. Makes sense. We don't want requests that are excessively broad or repetitious or systematic to clog up the system. And it's not clogging up the system. We've got a 43-day response time here. So, what did the drafters of these amendments on direction from Cabinet do? They said, aha, here is the solution we've been looking for. First of all, you have to apply to the Commissioner, so we'll put it on the Commissioner. But we're going to make it really clear the approach and the criteria the Commissioner has to apply. So what are we going to do? Well, first of all, we're going to add a new section saying the behavior of the applicant is abusive or malicious. So, abusive or malicious. So are we saying that the public body has no other way than to deal with a request that is abusive or malicious than to not respond to the request at all? Is there no other mechanism to address or deal with an abusive or malicious applicant? And I don't know the answer to that question, but I'll certainly be, if this gets to committee, be asking that question and asking the specific instances of information access requests that led to the need for this. What is the problem we are trying to remedy? Is this, once we had somebody come and threaten us and we didn't have any ability to deal with somebody being abusive or malicious, so we need to amend the Act so we don't deal with the request. Maybe the information requested is vital to that person being able to understand how they're being treated by government. And so there's no ready justification for that amendment, and I'll certainly would like to see it go, and I've said that at the beginning, and we'll deal with it, as I said, in the event this ends up getting to committee. But the next one is really the winner, the Oscar winner of the Freedom from Information Award for 2026. Responding to the request would unreasonably interfere with the operations of the public body or the government of BC, or the request is an abuse of the right to make the request because it's repetitious, systematic, or exceptionally broad. So we took out the reason. We don't have to have a reason. It's just unreasonable. It's unreasonable. I've got stacks of other work to do. I've got budget cuts. I've just had staff around me laid off. I can't deal with this right now. It's unreasonable. And then what's been responded to, I gather, in some other forums over the last few days is, well, but that's the commissioner. That'll be the commissioner's decision. Well, yeah, it'll be the commissioner's decision, but any lawyer worth his, her, or their salt can create a compelling argument that, well, we really like freedom of information, but sorry, it's going to unreasonably interfere, and the hallowed objective mythical person test, here are the facts that that type of person would say, yeah, it's going to unreasonably interfere. This is a definite Trojan horse. They're all in, it's the cumulative impact of these changes that effectively makes the public body the judge and juror on whether and if you're going to get the information you request. I'm not talking about the personal information. I support the amendments that deal with helping out MCFD deal with their 121-day response time and focus it and reduce the number of pages on that initial step. I'm talking about those that are charged, publicly minded citizens, media organizations, political parties, businesses. This is for businesses too. In fact, in 1992, businesses were supportive of this legislation because it opened up access to information they need to do their work and to build this economy. So this section is, in combination with the others, going to eviscerate what's left of this act. And save the best for last. Save the best for last. So, what have we got? We've got legislation that takes us right back to the beginning, where the amount of information you receive will depend on who you are and why you want the information. And this legislation equips us to go back to 1990, all in, I don't know, under 10 sections. But now I just want to touch on the one I mean, there's so many. It's so clever. But the section 25, 26, and 27, 28, we don't, most people don't enjoy reading legislation the way some of us do. Like, we might sit down and you know, depending on your interest, you might get a nice cup of chamomile tea, or you might get a glass of red wine, or for me, it's a coffee, a black coffee, thank you. I love that, sitting down with a black coffee. And you start reading this legislation, and then you get to section 25, section 26, 7, and 8, and you do a word search, or if you're like me, you actually read it because, you know, it's the old way of doing things. And, oh my God, there's a word. What? It's before. Before, in each of these sections, there's the word before. Oh my God, this act, these changes are retroactive. So if I've got a particularly embarrassing file sitting on my desk from a year and a half ago that I haven't dealt with, that's going to be really embarrassing, probably before I was elected as MLA, and it still hasn't been responded to, I can use these sections to shut it down. That's what retroactivity means. Or I've got a production of documents and the general category is going to be a little troublesome. Oh, I better talk to the government and see how we're going to fix this. So that is really, really a bad step. That to change the rules in the middle of the game, to create retroactivity, to eliminate the right the public has to information retroactively, that I'm speechless. I'm speechless. So those are the changes. So remember these numbers: 1, 2, 3, 4, 5, 6, 7, 13, 15, 25, 26, 27, 28. Take those out, and the third party will support this legislation. Or better yet, let's come to the next step in Groundhog Day. And why do I call it Groundhog Day? Because every 6 years there's a review of the legislation. And what does that review do? It's an all-party committee. Imagine an all-party committee, a committee that actually works across party lines and develops collaboratively recommendations for change. So, this is what the Act should be doing. It should deal with, let me drum roll, 34 recommendations made by the all-party committee in 2022. But the best part, I get excited about this stuff. This is right up there. And why is it right up there? It's openness, it's accountability, it's transparency. It's the foundation of our democracy. We can have amendment bills galore, but this is the legislation that provides the information to hold governments to account and provide information that British Columbians need in order to conduct their affairs. So, I'm just going to read out the ones that have been recommended repeatedly and ignored repeatedly out of the, 34 recommendations. So, culture of transparency. Add a duty to document to the Act. Oh, that was recommended in 2016 and nothing happened, and nothing's happened now. Amend the definition of public body to ensure that any board, committee, commissioner, panel, agency, or corporation created or owned by a public body is subject to the Act, regardless of whether it is listed in Schedule 2. Oh, that was recommended in 2010 and 2016. Oh, let's go down to recommendation 6. Clarify the discretionary exception for advice or recommendations does not extend to facts upon which they are based, or for factual investigative background material, or for the assessment or analysis of such material, or for professional or technical opinions. That's the recommendation to fix what was wrong in 2010, and it was recommended twice before. Nothing's happened. Recommendation 10, ensure that information held by public bodies is considered public by default. similar to 2004, 2010, 2016. And I will perhaps give the government, in a spirit of generosity, some credit on that one, because I believe that the recommendations related to better and more effective disclosure of personal information to reduce the 121-day wait are good. Reduce the timeline in which a public body must respond or access request, or extend the time responding from 30 business days to 30 calendar days. Oh, I remember talking about that earlier this afternoon. Amend the Act to provide an automatic waiver of application fees and processing fees for applicants when a public body has failed to meet the statutory timeline. Oh, that's been recommended before, and why not? No consequences for missing your timeline. Well, in the real world, there are consequences, and consequences affect behavior. 19, amend the Act to establish that an applicant who makes a formal access request has the right to anonymity. I can't believe that's here. We made it as a policy matter that requests, application requests, had to be anonymous. That's been recommended 4 times. And of course, if the name of the applicant is not anonymous, then we'll know which of these multiple provisions in Bill 9 we need to apply. Oh, God, Von Palmer's applying. Uh-oh. Rob Botterell's applying. Uh-oh. We better shut her down. Delay, delay, delay. New technologies. 22, draft and consult with the OIPC on regulations that address transparency, privacy protections, and oversight for data. Oh, that's been recommended before. Oh, 26, add to Section 29 of the Act a requirement about correction of personal information. Oh, that's been recommended before. Oh, 27, enact new comprehensive health information privacy legislation. I think this is partially covered, perhaps. But if not, it's been recommended twice before. 33, extending the 90-day period in a manner consistent. That's been recommended. And then 34, twice, amend Section 42 to expand the Commissioner's oversight by granting the Commissioner the jurisdiction to review matters or allegations of unauthorized destruction of... Oh, that's been recommended twice. Now, I will say that if members opposite wish to point me to legislation that has enacted any of these 34 recommendations, I'll be more than happy to correct the record. I just want to make public note on the record of the fact that as a relatively new MLA, I'm in learning mode, and the other day, the Minister of Jobs and Economic Development graciously apologized for an error on the record that I pointed out, and I'm learning from that. So if all of those recommendations, 34 recommendations, have been implemented, boy, I'm going to be the first one to withdraw any concerns I may have raised and compliment the government. So I've been listening over the last few days as to some of the coverage and some of the response. These amendments enable applicants to get the right information, so we got to make the amendments. Great, okay, but I agree in terms of personal information, but you know, the record on freedom of information is actually quite good. It's, what did I say, 43 days. And so people must be getting the information they're looking for. It's just not quick enough, and it's not, it's exempted, parts are blacked out that shouldn't be. OIP oversight. Oh, this is all okay. The Information and Privacy Commissioner will keep us honest. Yeah, but you've set the rules of the game around delayed response or not responding to a request at all in a manner where if you can construct an argument that it would unreasonably interfere with your operations, you can ignore the request. The commissioner doesn't have the ability to modify the direction you're giving him in this amendment. So that's just a red herring. Oh, there's too much information for us to deal with. Well, hold on a second here. There is too much information involving the Ministry of Children and Family Development. I grant you that, and you've got amendments in here that we're not objecting to that address that. But there isn't a problem on the FOI side. These amendments are not needed. What is needed is a stronger commitment to implement the changes recommended by the All-Party Committee in June 2022. All of them, not just the ones that have been made repeatedly. And then, I love this one. I won't call it ageism, because that probably was never the intent. But every once in a while I hear words like, but Rob, things are different than 30 years ago. We have more information. We have, we have a lot of things on our plate. Well, give me a break. Give me a break. Or, as my caucus team likes to remind me, I need to bring my language into the 21st century. So, be so for real right now is apparently how you say, are you serious? So I just want you to know that I'm trying to stay in sync despite my advancing years. So where does that lead us, that little pearl of wisdom I just provided? Well, I have to check my notes because I think that we're getting pretty close to the wrap-up of my second reading speech, but I do have 32 minutes. And I expect I'm aiming for 2 full hours here, and so how are things how are things different in a good way since 30 years ago? We have huge data management capacity. We have ways to access and organize information that we couldn't even imagine when I was using a BlackBerry. We have a way, we can put our effort in, and I can tell you when the Premier or any minister says, find me the information because I gotta be ready for estimates, that information is magically gonna appear very quickly. So I grant things are different than 30 years ago, but the ability to use information technology and information management to achieve achieve the targets that are set in the Act, it's there. The will to use it may not be, but the technology is there, and we are responding, the government's responding, public agency, in 43 days. Let's get it down to 30. Let's innovate. I know, let's use some of the Look West funding to establish a world-leading information management system that we can sell to everybody so we can actually get the response time down to 10 days instead of 43 days. And let's look at the way that We have organized briefing materials and reorganized them so it facilitates disclosure rather than creates the task of blacking out and turning it into a patchwork quilt. I may be giving my colleague a bit of a warning, because it's just possible I might not get through 2 hours here. We in the Green Caucus will not be participating in this final evisceration of freedom of information in this province. We will not. I've named the sections that need to be withdrawn, and the balance of the Act is deserving of our support, and we will support it at second reading if it didn't have all those other sections. And my understanding is that, you know, depending on what happens at second reading, and we'll be voting against the bill in second reading, if it gets to committee, we'll be looking to see what government does in response to our request for those sections to be removed. So, in simple terms, we cannot support this bill in its current form. There are many other provisions in the Act that haven't been used in the way that they could have been. We've dwelt this afternoon a fair amount on routine disclosure and the lack of use of information technology and the lack of willingness to innovate in the way in which policy documents and cabinet documents and briefing notes are structured to facilitate access. And I always wonder if sometime, you know, in the next 25 years, we might actually see the consultative committee that's provided for in the Act meet a few times, because that was going to be and was intended to be a mechanism to build understanding consensus around the successful operation of the Act. We're calling on this government and every member of the caucus to follow the path set by Premier Harcourt, by a former Attorney General Colin Gableman, former Premier Harcourt, former MLA Barry Jones, and a unanimous legislature in 1992 to take the steps to return to open, transparent, and accountable government, to not proceed with this legislation in its current form. Every single NDP member in this House must speak up for democracy. Your children, your families, your partners, everybody you know is counting on you on the government side to stand up for democracy, to the end. The ends do not justify the means. The promise that was made in 1992 has been broken, and you need to work to make it right. We fundamentally need to stand together, and I am not at all interested in how we got to today with Bill 9. I am interested in where we go tomorrow. And we still have time as a legislature to stop, take a deep breath, and either pass the legislation, the parts of the legislation that don't eviscerate freedom of information, or pull the legislation. But fundamentally, this is an important moment in this government's commitment to keep the promise of a unanimous legislature that has stood the test of time up until now. And what do I mean by that? I don't mean that there hasn't been disappointments and backtracking on freedom of information. And every report, every 6 years, has provided government with a list of what needs to be done to fully keep that promise. But this act is really the last step. And what it does that none of the changes up until now do is it effectively returns us, as I've said, to the way government handled information prior to freedom of information, which is who gets the information and what they get depends on who you know and why you want it. And that is fundamentally wrong. And so I'm going to conclude by reading into the record who holds the future of democracy in this province in their hands. Who holds the future of freedom of information in their hands? Because in a month's time, in 5 years' time, in 10 years' time, it will be possible to look back to the day in which this legislation was either pulled, passed without these horrific sections, or it was passed intact. And so, what I want to do is I want to respectfully ask each NDP, MLA, to think carefully about how you will proceed with any votes on this bill. We have the member from Vancouver Strathcona. Please, please think about this vote in a different way than others. Please preserve freedom of information in this province. I urge, I plead with all NDP members to do the same. The MLA from North Vancouver Seymour, the MLA from Kootenay-Monashee, the MLA from Esquimalt-Colwood, the MLA from Vancouver Fraserview, the MLA from Burnaby South Metro Town, the MLA from Nanaimo Lanceville, the MLA from Juan de Fuca Malahat, the MLA from Surrey City Centre, the MLA from Vernon Lumby, the Minister of State for AI and New Technologies, the member from Ladysmith Oceanside, the member from Cowichan Valley, the Minister of Citizen Service, the member from Burnaby East, the member from Vancouver Kensington, the Minister of Social Development and Poverty Reduction, the Minister for Surrey Guildford, the MLA, the MLA from Burnaby North, the Minister of State for Community Safety and Integrated Services, Minister of Tourism, Arts, Culture and Sport, the Minister of Infrastructure, the Minister of Children and Family Development, the MLA from Vancouver Langara, the Minister of Housing and Municipal Affairs, Minister of Emergency Management and Climate Readiness, the MLA for Coquitlam-Malheursville, the Minister of Labour, the Minister of Education and Childcare, the Minister without portfolio, the Minister of Indigenous Relations and Reconciliation, the Minister of Jobs and Economic Growth, the Minister of Post-Secondary Education and Future Skills, Minister of Finance, the Premier, the Minister of Transportation and Transit, the Attorney General and Deputy Premier, the Minister of Energy and Climate Solutions, the Minister of Agriculture and Food, the Minister of Forests, the Minister of Environment and Parks, the Minister of Public Safety and Solicitor General, the Minister of Mining and Critical Minerals, the Minister of Health, the Minister of Water, Land and Resource Stewardship, the Minister of State for Local Governments and Rural Communities. I ask you all to individually reflect on freedom of information, what I have said today, and urge you to consider voting against this piece of legislation at second reading, or alternatively, voting in support of amendments in the balance of the legislative process, if it gets past second reading, to take out the provisions that put freedom of information in this province at the end of its lifespan. And this afternoon, there will be many who say, it's no big deal, it's just performative, but I've tried over this last hour and 40 minutes to lay out the history of the Act, the promise of freedom of information that was made when this Act was unanimously passed in 1992, and the steady chipping away at freedom of information that's happened, to outline the reason some of the provisions are needed in this Act to deal with MCFD and the challenge it faces in relation to personal information requests, the complete lack of justification for the other amendments, which effectively turn the clock back to a time when it was not freedom of information. And we all have caucus solidarity, and we all have whipped votes, and we all have that. But I'm asking you to think carefully about what you will say to future generations if this Act is passed, and for all of the reasons I've outlined, it brings the fundamental aspect of open, accountable, transparent government to an end, and that is access to information subject to limited exemptions that is timely, because delayed access is delayed, denied, prevented access. So to repeat, delayed access is denied access. And this Act, with those amendments, completes the effort that has been undertaken over the years to eviscerate this legislation. And it's up to the NDP colleagues across the way to individually decide whether they want to be party to that outcome. And why do I say it's up to the NDP MLAs on the other side of the House? Because we've seen time and time again in this legislature that a 22-vote win is treated as majority government, and we end up with a tie vote, and then we end up with the Speaker breaking the tie in favor of the legislation that is being brought forward by the government. And you have an opportunity to reflect on whether you want to be a part. This legislation is far more important than other legislation because it's the foundation of how democracy works in this province. Thank you.